The next matter to come before us this morning is State of Ohio versus Danielle Norris. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning. I can keep you apprised of the passage of time. We've read the briefs and we're ready to see when you are.
Good morning, may it please the court. I'd like to reserve 3 minutes of time for rebuttal if necessary. In addressing the court, I'd like to start with actually assignment of error.
And counsel, if you could introduce yourself. I know.
I represent the appellant. My name is Nicholas Hannick. Thank you. Apologies, Your Honor. I'd like to start with the assignment of error 3 as far as what the court's jury instruction that the court had already ruled the search of the premises at 220 West 15th Street on February 3rd, 2012 was a legal search. And I'd like to talk about and go over what the potential of this instruction would be to a jury. While there were some questions regarding regarding a search of the premises that did occur during the trial itself that were objected to and were sustained, and the court did give instruction to the jury at that time to disregard those questions, this instruction to the jury is fraught with a number of issues that would confuse lay people. You have the two words that I want to focus in on, and not to seem over the top or otherwise, but what we see as legal search is not what a jury would see as what legal search means. There is the word legal coming from a judge, and the word search. Search to an attorney is sort of a technical term of art. Search to a lay person is looking through, effort, expending. It's not look, it's not view. It's I did something to look through. Now, the argument that defendant made, which the jury is free to consider just as much as anything else. They can determine the credibility of police officers just like any other witness, as the instructions are so, was that the police manipulated the scene to look more like she had knowledge of what was going on than what she actually did. So when they hear that the jury gets the term search, search implies I'm searching for my keys, I've moved these things around, I've taken things out of the drawer, I've combed the beach searching for treasure, I've moved the sand, I've done this. Search could imply to them that anything the police did there would have been okay. The defense argument that the police, to the extent that I think the judge properly allowed them to get into, may have phrased the scene in such a way that showed items were at a place they may not have been, is an argument that is permissible to make. Regardless of the wisdom or intelligence or strategy of going for to say the police may have moved something, the jury is to treat them like any other witness. So the two parts, the one word search, I think has implications beyond the basic word, and the second is a legal search, coming from a judge. The same, in a way, there's a very, very broad question there whether or not the jury would consider that to be, that's okay. Now, in the verdicts, the jury found that...
I'll stop you for just a moment. What was the request? Was there a request made by counsel that the court should give a more specific instruction?
The counsel for Ms. Norris objected to the instruction. I think this is out of the court's, I don't believe this was a request by the state of Ohio. The court came with, these are what we're looking at as instructions and went over them. I don't think there was a request for this. I think this was the court trying to deal with an issue that it perceived during the course of the trial. In that I think there were a number of times that defense counsel was properly cut off from going into whether the search whether it should be permissible at all.
Which should have been dealt with in the suppression motion.
Yes.
And the court did not.
Correct.
Okay.
And what happened with the suppression motion is there was one suppression motion filed on a different issue. A second suppression motion filed on this but was withdrawn. So wasn't really a play here. However, I think the argument of where and how did the police photograph things? Where and how were things found? Did they try to make the scene look more like she could have knowledge? Is something that I think was relevant to go into, and I think that instruction precluded the jury's consideration of that, or at least influenced the consideration of that. So I guess what's at hand here is that how did that influence that, given that the issue is that it's kind of splitting between what could have been a suppression and what was allowed at trial. And I think the court actually did an okay job during the questions and during the objections of limiting where that was going. But then they put this instruction in, which I think would just confuse lay people.
And then again, back to Judge Moore's question. Then the court puts this instruction in, and what happens at trial with regard to this charge to the jury? Does defense counsel at that point say, Your Honor, have a problem with what we just said? What happens?
They objected.
Okay, so during jury charge, they objected.
Yes.
And that objection was specifically to this.
Yes.
Okay.
Yes, there's a proper objection to this exact statement. During the pendency of the trial, they tried to put in evidence regarding these points, but there was objections and they dealt with those at the time. And the court said to the jury properly when those things came up, disregard that, disregard this. Those were limiting. And I think the court, probably out of an abundance of caution or concern as to what the complicated pre-trial matters were, put this in here. But unfortunately, it has an unintended, and what I'm arguing is this could have an unintended effect. And it's a strange, and the verdict in this case reflects that they found her not guilty of possession of the trafficking, meaning you could see a world where it's possible the jury went, well, we don't think she had it, but they told us that they had that stuff, the search was okay, and everything was, so we can't disbelieve that. So they could see, come to very strange verdicts, and juries are free to disbelieve or believe anything based on putting a police officer on. They can find them totally, they can believe absolutely nothing. They're free to do that, and that's their right. And that argument is something that we can't allow to preclude. That would be as a prosecutor, I had juries tell me that we didn't believe the doctor, we thought their administrator. We thought this body part was somewhere else in the body. They didn't prove that. But we never were able to put instructions that say the body looks like this. They can believe whatever they want. And we can't take that, the court can't take that away from what the jury is free to believe or not to believe. And so that's why I think this instruction, while the court is trying to deal with what it assessed was a legal problem during the trial, it was a lot of issues that came with the jury. I'd like to, if there's any other questions on that point, I would take them at this point. Otherwise, I would move on to briefly touch on the assignment of error 2, which I think is also important. In this issue, she was not allowed to talk about, she was able to talk about some of her current mental health conditions, but she was precluded from going into what her history and background of PTSD and relationship with men in general. And I think this is relevant to the point of knowingly, because the charges of whether or not someone could knowingly have something around when something is there and not necessarily know. And I believe she could have testified as a layperson to some of that background as it was relevant to that extent. I think the court was elaborating on perhaps it would be unnecessarily sympathetic, but it does not. The issue here is how was that relevant? And the defense was trying to argue that this was a controlling relationship, where this is someone that was running every aspect of her house, and based on her PTSD and her background, she would not have known that these things were happening, because there are reasons that would come into play there. Her history would have been relevant. Because it would have shown that pattern. It would have been something they could consider. This is something that is regularly found to be relevant In other situations, sometimes through the use of an expert, not an issue here, in PTSD, in battered woman syndrome, things of that nature, regularly and routinely, this is found to be relevant. And in this case, the court did not allow that to come in. And this is interesting in that the state of Ohio then further on argues in the closing argument that she was able, well, you don't need to, she was able to stand up for herself starting at the age of 13. And that's part of the argument the state of Ohio uses when she was precluded about talking about some of the history and background explicitly by the court. This time I would just reserve the rest of my time for rebuttal. Thank you.
Good morning, Your Honors. May it please the Court, Mary Smolanska on behalf of Appellee of the State of Ohio. I would similarly like to start with the third assignment of errors, as my opposing counsel has done. Regarding the jury instruction, first of all, and I pointed this out at page 24 of my brief, the defendant only cites part of the instruction that was given. The law is clear that you have to consider the entire instruction, and you have to consider that instruction that's at issue here in light of the entire charge to the jury. In this case, what the court instructed was that consent to search the premises was not an element of the alleged offense, of any charged offense, and that the court said, you may not consider any testimony or documents relating to the search for any purpose other than how it may or may not affect the credibility of witnesses. And I think that really addresses the argument that that you're hearing today from defense counsel, that this instruction somehow prevented the jury from believing that the police may have manipulated evidence or tried to make it look more like she had knowledge of what was going on. In other words, and what was argued at trial was Ms. Norris testified there were no drugs sitting out. She was not aware of any drugs, and that she did not come right out and say, well, the police must have taken them out. But she said, when the police came in, there was no cocaine. There was not a plate of cocaine sitting on my counter. In fact, the police had said it was a white plate. She said, no, I only have red plates. She testified that in her bedroom, the tray table was put up, that that there were no drugs that were out on that tray table when the police came, and that, if there was anything, it belonged to the defendant, and that's where it must have come from. So in other words, the innuendo or the inference that the defense counsel wanted the jury to draw is that the police did act improperly and manipulate this evidence. And what the court instructed the jury was that the consent, in other words, the coming into the home, was what the court had ruled that was legal, that the search of that premises was legal. But the court also further said, but you can consider any evidence that I've allowed in regarding this, i.e. Ms. Norris's testimony and the manner in which the officers were questioned. You can consider that as it may affect the credibility of any of the witnesses, the police. So she was able to argue that she wasn't aware of any drug dealing because she frequently didn't know that Mr. Norris was in the home, that none of these things were out when the police came, that she was upstairs, that he'd been in the house earlier, and she didn't know what he may or may not have done. And so she's trying to give the jury the impression that the police removed these drugs from the nightstand, put them out on the tray table, then photographed them and said, that's our basis. The plain view was the basis for obtaining the search warrant in this case, and that the court had ruled was a legal search based on the suppression issues that were raised. And the police went further and photographed that evidence. So she's saying you shouldn't even consider the photographs because obviously the police could have manipulated that evidence and gotten it out. And that comes down to a credibility issue because that's not what the officers testified to. Contrary to, you can't consider that argument, I think, in a vacuum. You have to look at all of the trial testimony and the entire charge to the jury in this case. And the court instructed the jury as to their burden of proof that they had to find beyond a reasonable doubt that she was complicit in the preparation of these drugs, she was convicted of the permitting offense, that she had permitted Mr. Rivera to use her residence to sell drugs. And the overwhelming weight of the evidence in this case was that these drugs were in the house, that they were open and obvious in the house. In fact, there was a box that had a bag in it. If you can imagine, rolled down and sitting there with this powdered heroin that any errant sneeze, as the officer testified, could have sent scattering about the room. And in the brief amount of time that the officers were in the bedroom, it's hard to imagine that they could have pulled all of this out. And that kind of goes to that sufficiency and manifest weight. I also think that I disagree with counsel's argument that the term legal search would be confusing to a layperson, that term would have some other meaning to them. The court gave them an explicit instruction about what they could or could not do with the evidence, that the court had given leeway and permitted to come in regarding the, regarding the legality of the search. And the court ruled that the search of the premises was a legal search. And I also don't see that the jury would be confused by the term search, as in to go through something, because what the officers testified, and you have to consider that charge in light of all of the evidence admitted at trial, because that's what the instructions are based upon. The court said, the testimony was that the officers had come in, that they photographed these drugs out on the table, and everything that was sitting out. So at that point, the jury, I think it would be clear to anybody, they're not searching. They said, we conducted a protective sweep of the residence because we had these drugs sitting here. We were going to have to let her go upstairs to get her children who were in the upstairs bedroom of the house, and they wanted to make sure that while they're waiting for the search warrant, that there's not going to be somebody popping out of a bedroom or another room or a hallway with a weapon. And they conduct a legal protective sweep of the residence. And I'm sorry, I'm losing my words.
No, I just thought you were going to say a legal search.
No, not at that point. No. A protective sweep of the residence, which is permitted, and that's part of what the court had ruled regarding the legality of the search. That they'd seen these things in plain view when they were properly looking for any person with weapons. They testified, we didn't go through anything, we didn't open closets and drawers, we didn't take anything out. It was simply sitting there. We left, got the warrant, and officers sat.
They made small talk.
They made small talk, exactly. They sat at the table with her and made small talk. Certainly the jury was able to look at that, and that was part of the whole credibility argument, because she's saying, no, we didn't, that's not what happened, and they never asked me for consent to search the residence. And that's why that instruction comes into play and why it's proper, because she actually testifies, I didn't consent to a search of my residence. So the court feels that the jury is being misled and asked to draw inferences from this testimony that the police acted improperly in asking about consent, going into the residence, seeing the things in plain view, and then conducting a search based on a legally obtained search warrant, which is, I believe, what the basis of the issue was on the suppression, was the legality of the warrant. And I think that the fact that the instruction is more than just what was represented in the defendant's brief, that the court went ahead and said, consider it for credibility, makes it a proper instruction. I don't believe that there was any error, and I believe the defense counsel was able to make all of the arguments regarding the credibility of the police officers based on Ms. Norris's testimony. And he emphasized that in his closing. She didn't consent to this. She didn't know that these drugs were here, and certainly from that the innuendo is, so the police must have planted them. And I don't think that was the basis of. I think that was the basis of the court's concern, was the misleading of the jury in that manner that they felt the need to correct. With regard to the second assignment of error in the history of Ms. Norris and her history with Mr. Rivera coming in, the court allowed wide latitude. Defense counsel was given wide latitude. There's a wealth of evidence in the transcript to show that Ms. Norris was able to testify to the medical conditions that she has, to her history with Mr. Norris dating back to when she was 13, and to basically all of the things that they're arguing they weren't allowed to get into. I think they additionally wanted to offer evidence that Ms. Norris couldn't form the mens rea element of knowingly based on all of these mental conditions. And certainly some of the evidence and the arguments that were presented at trial and here today would seem to indicate that what she's saying is she couldn't have knowingly possessed these drugs because she was under Mr. Rivera's control. Well, that certainly speaks to a defense of duress, and there was never a defense of duress offered. There was no notice of a defense given for duress, and it was never argued to the jury. So I think that it's misleading to say that that evidence would have come in regarding duress because it wasn't given. It was more in the vein of she couldn't have formed the mental capacity of knowingly to commit this offense. And that's a diminished capacity of defense. Based on my mental condition, I couldn't knowingly do something. And diminished capacity, as the court is well aware, is just not recognized in Ohio as a legal defense. I think that the court under Evidence Rule 403A had a duty to exclude the evidence because the probative value did not substantially outweigh the prejudice to the jury, the confusion of the jury. In State versus Soren, which is the 12th district, the 12th district held that the judge was in the best position to determine the impact of the evidence and whether it was relevant or not, or confusing or misleading to the jury. And in this case, the court determined that, although it had allowed a wealth of evidence in, it drew a line and said, but her suggestion and her argument and her testimony that she couldn't knowingly have possessed those drugs because she was under Mr. Rivera's control, that she was unaware of things that he did in her home, all of those kind of things just simply did not, would have been confusing to the jury. And especially in light of, I think what was kind of unspoken at the trial is this battered woman syndrome. And certainly that wouldn't have been proper in this case because what you're looking at is typically we see a battered woman syndrome defense in a domestic violence case or some type of an assault or physical violence case, usually to the person that is the alleged batterer. What they wanted to get into at trial was her history of having been sexually molested by someone else and her reaction to it, the fact that she often saw, in her mind, believed that she saw men in her bedroom, which is not uncommon for someone that's suffered that. But I think that the court said at the point that they're offering this evidence to argue to the jury that she can't act knowingly because she was because her mental capacity affected her to the point that she was in a state of diminished capacity. They're not offering an insanity defense to say she was insane at the time of the offense. They're trying to offer history dating back to when she was 13 years old and got out of an abusive situation where she was being molested. And I think the other thing that was relevant was there was some suggestion that she would have had to submit even to the authority of the police officers when they were conducting the search of the home. And I think, again, the record and the testimony that did come in would belie that point because as the prosecutor highlighted, and this is what defense counsel referred to in the closing argument was, the state pointed out after having cross-examined Ms. Norris about this, she was able to leave an abusive relationship where she was being molested by an adult male. She was able to tell the officers that she did not want to consent to the search of the home, and that's whether you view it based on her testimony or based on the officer's testimony, because one thing is perfectly clear. She said, no, you can't search my home because they didn't get the consent. That's why they got the search warrant. That's why the consent form was ripped up and thrown in the garbage because the officer had started to fill it out when she initially said, I'm going to consent, either she made or received a phone call, spoke to her brother Wayne Norris, and based on that, she said she wasn't going to consent to a search of her home. And that's what Mr. Norris, according to her testimony, and the officers had advised her, and she was able to essentially resist these 5 officers, as the prosecutor argued, that she was able to stand up for herself in this case. So I don't think this a battered woman syndrome defense would even be appropriate. Certainly, the court did give them very wide latitude in offering this evidence, and I think that the court properly drew a line and sustained the state's objection based on evidence rule 403, that mandatory exclusion of the evidence because they had reached a point that it was going to become misleading to the jury, and that they would need an expert to explain the effects of all of these syndromes and her fear of men in general to the jury, and that had not been offered. And if there are no further questions.
Thank you.
Thank you. To address a few points that the state has brought up. A lot of what the state reiterated to you is much of the testimony put forth by the state of Ohio in this trial regarding what the police did in the search. The question is not this court is not whether or not those police are to be believed or not to believe. The question is, did that take it out of the jury's hands when that instruction was put in there? It would given that there were some instruction, there is this instruction that's potentially misleading that is not defined. Legal search is not followed by a definition of what legal search is. That's why we have to argue about this here today. Ms. Norris could have gotten up there and argued and said, there are no drugs. The drugs weren't there. Would the court have put an instruction in that said, yes, there were drugs there? You know, in the instructions? That's kind of the equivalent here. Can you make any defense that you want, and is the jury free to believe or not believe anything? Yes. So we can't look at it as in we need to bolster or deal with what the search or what is a search, how that entails. Just have to go with what she's charged with, explaining that to the jury and not try to not mislead them. And that's the danger we have here. She can make any kind of defense that she wants in this context. It could have been far more outside of the box in this. But simply put, if she's saying her defense in this case, as it was, is the police might have moved something around. The jury needed to be able to consider that. Even if it was, hey, maybe there was a plate that they took it this way so they could take a photograph a little this way. The jury can think about that or not think about that. The jury can go back there and flip a coin. The fact of the matter is we don't know how they decided, but there's an instruction that is potentially misleading to them. And that's what I want the court to consider as trouble. I'd also, as far as the knowingly and as far as whether or not there is no duress. I don't believe it fits under duress. I don't believe it fits under affirmative defense. I believe this goes right to the heart of knowingly. And I would argue that it is strange that the state argued that she was able to leave these abusive relationships, and at the age of 13 she's able to do this, but they're not allowed to hear about what that all meant. They can argue one way and say she's really like this, but you can't go into the details of what happens in traumatic abusive relationships, susceptibility of further abuse, and I do think while an expert could have laid that out there, and that was not an issue here, lay testimony would have been proper as long as she didn't come to conclusions about it that would have been outside of the depth of it. But a layperson can go, well, she had this kind of experience where every time a man was in her life, they made her do X, Y, and Z. So maybe she didn't go into that cabinet because that's where he said not to go, or something like that. This sort of set of rules or things that she's used to that sort of following. So I'd ask that you consider the jury instruction in light of that she can assert a defense and it may have precluded the jury's consideration. And I think a misleading instruction, even in a larger context, is a troubling consideration. And I hope that you consider that. Thank you. If there's no other questions.
Thank you, counsel. Thank you, thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted on the advisory